Hello viewers, in our previous lesson we studied about making of arbitral award. Today we would be dealing with the topic of recourse against arbitral award and enforcement of award. The objectives of this lesson are to examine the procedure for recourse against arbitral award, to analyze the grounds for setting aside the arbitral award, to study the procedure for enforcement of award, to understand the effects of death and insolvency of a party on arbitration, periods of limitation and lien on arbitral award. The arbitral award is final and binding on the parties, and there is no appeal against the award on merits. But an aggrieved party may apply to appropriate court to set aside the award on specific grounds. Section 34 of Arbitration and Conciliation Act 1996 deals with setting aside of a domestic award. Similarly, Section 48 deals with conditions for enforcement of foreign award. The constitutional validity of Section 34 was challenged in TPI Limited versus Union of India 2001-3 RAJ 70 on the ground that it does not provide right to challenge the award on merits. The Delhi High Court upheld the validity of Section 34 and observed that when the parties have chosen the forum of arbitration and the arbitrator of their choice, it is not necessary to make a provision for appeal against the award rendered by the arbitrator. The legislature has the power to specify the grounds on which an award can be challenged, and it would be permissible for the party to challenge the award only on those grounds. If it were permissible for the court to re-examine the correctness of the award, the entire proceedings would amount to a futile exercise. Procedure for set aside of arbitral award. According to Section 34 of the Act, an aggrieved party may make an application for setting aside an award before the court only on the grounds specified under Section 34 subclause 2 of the Act. Let us look at the important aspects of set aside proceedings first. Appropriate court. The principal civil court of original jurisdiction in a district or the High Court exercising ordinary civil jurisdiction as defined under Section 2(1)(e) of the Act is the appropriate court for filing an application under Section 34. This has been confirmed by the Supreme Court in the case of State of Maharashtra versus Atlanta Limited 2014-11 SEC 619. Limitation. The Section 34 subclause 3 of the Act stipulates the application for set aside shall be filed within a period of 3 months from the date of receipt of the award. However, if the applicant shows sufficient cause for the delay, the court may entertain the application within a further period of 30 days, but not thereafter. In State of Goa versus Western Builders 2006 6 SEC 239, the Supreme Court held that the court could not apply the Section 5 of the Limitation Act 1963 for condoning the delay, and only the delay up to the period of 30 days can be condoned, but not beyond that. The Supreme Court in State of Maharashtra versus ARK Builders Private Limited 2011 4 SEC 616, clarifying regarding the calculation of limitation period, observed that the Section 34 subclause 3 shall be read along with Section 31 subclause 5, and the limitation period would commence only from the date a signed copy of the award is delivered to the party making the application for set aside of the award. Notice. An application for setting aside an award can only be filed before a court after issuing prior notice to the other party, and the application shall be accompanied by an affidavit of the applicant endorsing the service of the notice. This has been introduced under section 34 subclause 5 by the way of Amendment Act of 2015. Nature of proceedings. The proceeding under section 34 is not a regular civil trial. The Supreme Court in FISA Developers and Intertrade Private Limited versus Amkey Private Limited 2009 17 SCC 796 observed that applications under section 34 are summary proceedings with provision for objections by the respondent, followed by an opportunity to the applicant to prove the existence of any ground under section 34 subclause 2. The court generally permits filing of affidavits, cross examination if necessary, hear arguments and decides the matter. However, the court may vary the procedure depending upon the facts of the case. It is important to note that the court has a limited scope to interfere with an arbitral award under section 34. In P.R. Shah Shares and Stock Brokers Private Limited versus BHH Securities Private Limited 2012 1 SCC 594, Supreme Court observed that in the absence of any ground under section 34 subclause 2, it is not possible to re-examine the facts to find out whether a different decision can be arrived at, as the court does not sit in appeal over the award. Resumption of arbitration. According to section 34 subclause 4, in appropriate cases and upon request of a party, the court may adjourn the proceedings for a certain period of time in order to give the arbitral tribunal an opportunity to resume the arbitral proceedings or take such other action as in the opinion of the arbitral tribunal will eliminate the grounds for setting aside the arbitral award. The Supreme Court in Tamil Nadu Electricity Board versus Bridge Tunnel Constructions 1997 4 SCC 121 held that where an award is vitiated by an error of jurisdiction, the court can send it back to the arbitrator for rectification of the error. Time limit. By way of Amendment Act of 2015, in order to expedite the process, the time limit has been imposed upon the court to dispose the application for set aside of the award. As per section 34 subclause 6, the court must endeavour to dispose the application expeditiously within a period of 1 year from the date on which notice of the application is served on the other party. Appeal. Section 37 subclause 1 subclause C provides that an appeal lies to appropriate appellate court against the order of the court under section 34. Further, according to section 37 subclause 3, no second appeal shall lie from an order passed in appeal, but parties have right to appeal to the Supreme Court. Grounds for set aside of arbitral award. The grounds for set aside of arbitral award are provided in section 34 subclause 2 and they can be studied under two categories. Firstly, grounds which shall be proved by the applicant party, and secondly, the grounds which court may consider on its own initiative. It is important to note that exclusion of any recourse against arbitral award is not valid. The award may be set aside if these grounds are proved by the applicant. Incapacity. The parties do not have legal capacity to conclude a valid arbitration agreement under section 34 2A 1. If a minor or a person of unsound mind is a party he must be properly represented by a suitable guardian, otherwise the award would be liable to be set aside, because such a person is not capable of binding himself under a contract. Invalid arbitration agreement. The arbitration agreement is not valid under the law to which the parties have subjected it or under the law in force as per section 34(2)(a)(2). The validity of an agreement can be challenged on any of the grounds on which the validity of a contract may be challenged. In State of UP versus Allied Constructions 2003 7 FCC 396, the Supreme Court held that the validity of an agreement has to be tested on the basis of law which the parties have subjected it. Where there is no such indication, the validity would be examined according to the law which is in force. Lack of proper notice. The party making the application was not given proper notice of the appointment of an arbitrator or of the arbitral proceedings, or was otherwise unable to present his case as per section 34(2)(a)(3). In Dulal Podda versus Executive Engineer Dona Canal Division 2004 1 SEC 73, the court held that the appointment of an arbitrator at the behest of the appellant without sending notice to the respondent and ex parte award given by the arbitrator was illegal, therefore liable to be set aside. Exceeding the scope of submission to arbitration. The arbitral award deals with a dispute not contemplated by or not falling within the terms of submission to the arbitration. It contains decisions on matters beyond the scope of the submission to arbitration. However, if the decisions on matters submitted to arbitration can be separated from those not submitted to arbitration, then only that part of the award which contains decisions on matters not submitted to arbitration may be set aside by the court. This is provided under section 34(2)(a)(4). Improper procedure. The composition of the arbitral tribunal or the conduct of arbitral proceedings was not in accordance with the agreement of the parties or in conflict with the provisions of part 1 of the Act as per section 34(2)(a)(5). In Union of India versus Om Prakash Baldev Krishna, AAR 2000, Jammu and Kashmir 79, the Jammu and Kashmir High Court held that non-reasoned award is liable to be set aside by the court, because it is mandatory as per section 31 subclause 3 that the arbitral award shall state reasons for the award unless the parties have agreed otherwise. Some examples of misconduct of proceedings are proceeding ex parte without sufficient cause, denial of opportunity to parties, acting against the mandate given to the arbitrator under the agreement, failure or refusal to consider counterclaim of the respondent, etc. The award may be set aside if the court finds the existence of these grounds. Non-arbitrable dispute. The subject matter of the dispute is not capable of settlement by arbitration under the law for the time being in force as per section 34(2)(a)(6). Only matters of indifference between the parties to the litigation which affect their private rights can be referred to arbitration. Therefore, matters of criminal nature, insolvency proceedings and matters of public rights cannot be decided by the arbitrator. Against public policy. the arbitral award is in conflict with the public policy of India as per section 34(2)(a)(7). Apart from the above grounds, the award can be challenged firstly under section 13 subclause 5 when the challenge procedure against an arbitrator was not successful, and secondly under section 16 subclause 6 when the plea of lack of jurisdiction was rejected by the arbitral tribunal. The Amendment Act of 2015 has added two explanations to section 34 subclause 2 subclause b. These amendments primarily seek to clarify the meaning of public policy under section 34 and the scope of review of the court. The explanation 1 clarifies that an award is in conflict with the public policy of India only if it was induced or affected by fraud or corruption or in violation of section 75 or section 81 of the Act, which deal with confidentiality and admissibility of evidence of conciliation proceedings in other proceedings, or it is in contravention with the fundamental policy of Indian law, or it is in conflict with the most basic notions of morality and justice. Further, explanation 2 stipulates that the court shall not review the award on merits to determine whether the award is in contravention with the fundamental policy of India. A new subsection 2a has also been added to section 34. It provides that an award dealing with arbitration between the Indian parties can be set aside if it is vitiated by patent illegality appearing on the face of the award. However, the award shall not be set aside merely on the ground of erroneous application of law or reappreciation of evidence, but the ground of patent illegality is not available to set aside the award in international commercial arbitration. Prior to the Amendment Act of 2015, there was lot of confusion regarding the scope of the term public policy, and due to broad interpretation of the term, it led to excessive interference by the court. The Supreme Court in ONGC versus Saw Pipes Limited 2003 5 SEC 705 held that public policy of India is required to be given wider meaning, and it was opined that award is against public policy if it is contrary to fundamental policy of Indian law, interest of India, or justice or morality, or patently illegal. And this applied equally to both awards arising out of international commercial arbitrations as well as foreign awards. In Venture Global Engineering versus Satyam Computer Service Limited 2008 4 SEC 190, it was again reiterated that an award could be set aside if it is contrary to fundamental policy of Indian law or the interest of India, or justice or morality, or if it is patently illegal. In various decisions subsequently, the scope of the interpretation was restricted, especially for awards of international commercial arbitration and foreign awards. However, the amendment has completely done away with this line of interpretation. Presently, the meaning of public policy does not include the reference to interests of India, as it is vague and is capable of interpretational misuse, especially in the context of challenge to awards arising out of international commercial arbitrations or foreign awards. The ground of patent illegality has been retained for purely domestic awards, and the court has the power to supervise the application of Indian law in cases of domestic arbitration. Therefore, in the light of these amendments, the courts have to take a hands-off approach in international arbitration and a summary approach even on grounds of patent illegality with respect to purely domestic awards. Now, let us discuss about finality and enforcement of awards. Section 35 of the Act states that an arbitration award shall be final and binding on the parties and on persons claiming under them respectively. Section 36 subclause 1 provides that where the time for making an application to set aside the arbitral award under section 34 has expired, the award shall be enforceable under the Code of Civil Procedure 1908 in the same manner as if it were a decree of the court. Earlier, mere filing of an application under section 34 amounted to a default stay on the enforcement of the arbitral award, but this has been replaced by the Amendment Act of 2015. Now, sections 34 subclause 2 and subclause 3 provide that the party shall file a separate application for stay of the award, and the court can grant stay by imposing any conditions as it deems fit, including a direction for deposit of money in case of award for payment of money. Therefore, the court has been given the discretion to impose conditions prior to granting of stay, and this would facilitate speedy and just disposal of the disputes. Deposits as to cost. The section 38 of the Act empowers the arbitral tribunal to direct the parties to deposit the costs ascertained by it under section 31 subclause 8 in advance. Where against a claim a counterclaim also has been made, the arbitral tribunal may fix separate amount of deposit for the claim and counterclaim. The deposit shall be payable in equal shares by the parties. In case of failure of one party to deposit his share, the other party may pay that share. In case of failure of both parties to deposit the costs, the arbitral tribunal may suspend or terminate the proceedings in respect of the claim or counterclaim. In such a case, the tribunal shall render the accounts of the deposits already received and return any balance amount to the parties. Lien on arbitral award. Under section 39 of the Act, the arbitral tribunal shall have a lien on the arbitral award for any unpaid costs of the arbitration. Here, exercising of lien means refusal to deliver the award except on payment of costs. However, the aggrieved party may make an application to the court under section 39 subclause 2 in this regard, on which the court may order the arbitral tribunal to deliver the award to the applicant on payment of the costs into the court. Then, the court shall conduct necessary inquiry by hearing the arbitral tribunal and thereby order payment of reasonable sum of money to the arbitral tribunal out of the deposited costs. The balance amount, if any, shall be refunded to the applicant party. Further, if the arbitral award does not contain sufficient provision concerning costs, the court may make appropriate order on cost of arbitration. But if the arbitration fee is fixed by written agreement between the party and the arbitral tribunal, then an application cannot be made to court against the lien on arbitral award. Effect of death of a party. Section 40 subclause 1 provides that an arbitration agreement shall not be discharged by death of any party, but in such an event the agreement shall be enforceable by or against the legal representatives of the deceased party. Further, the mandate of the arbitral tribunal shall also not be terminated by the death of any party. Insolvency and arbitration. A person is called insolvent if his liabilities exceed the assets and he is not in a position to honor his commitments to the creditors. Under such a situation, he shall file an application before the court seeking a declaration to be adjudged as an insolvent. If the person is declared as insolvent, his property will be administered by the receiver appointed by the court. The receiver takes into account the assets and liabilities and pays a rateable dividend to the creditors as per the orders of the court. Under section 41 of the Arbitration and Conciliation Act 1996, in case a person is adjudged as an insolvent and the official receiver adopts certain agreements which contain arbitration clause, with the permission of the court, such disputes shall be referred to arbitration. It is pertinent to note that an insolvency application itself cannot be referred to arbitration by the court, as it is not an arbitrable dispute. Limitation. According to section 43 subclause 1 of the Arbitration and Conciliation Act, the Limitation Act 1963 shall apply to the arbitrations as it applies to the court proceedings. For the purpose of limitation, arbitration shall be deemed to have commenced on the date referred to in section 21 of the Arbitration and Conciliation Act, that is, on the date of receipt of request for arbitration by the respondent. If any time frame is provided in the arbitration agreement to commence arbitral proceedings, and if the stipulated time expires, the court is empowered to condone the delay and extend the time for an appropriate period. Finally, if an award is set aside by the court, the period between the commencement of the arbitration and the date of the order of the court must be excluded in computing the time prescribed by the Limitation Act for the commencement of any other proceedings with respect to that dispute. Hope you enjoyed this lesson. Thank you.